the starting point, published it, which they don't normally have a problem with, that you've identified them, not necessarily by name, but that people knew it was them that you were speaking about, which raises the spectre of it's even more dangerous not to name sometimes, because if you said something rude about a member of the England football team, something highly damaging about a specific individual, and you thought, well, I don't really have the courage to name they. Well, obviously 10 of the remaining members of the team are not what you've just said they are. And unfortunately, if they can show that people thought it was them you were talking about, they could sue you in what is a journalistic nightmare, a group libel. In other words, where you're being sued by a variety of never meant, but who can show that people are very. So, generally speaking, it's not a solution to blur the identity of somebody. It's better to presume that you're going to name somebody and then see if you've got the courage to write what you intended to write anyway. The third thing they have to show then is that it's defamatory. In other words, that it lowers them in the eyes of right-thinking people or injures them in their job, trade or profession. In other words, that it's the sort of things that are defamatory are, and the key words here are that it would tend to, they don't have to show that they have been damaged. The jury will presume damage. So, for example, if we say falsely that somebody is a prostitute, they don't have to show that they've been avoided in the street or that they've suffered financial loss or anything like that. The jury is going to presume that it's damage. So the statement is false. So they don't have to show injury or damage. They don't have to show intent on our part. And I think it's fair to say that about 90% of all libel actions stem from mistakes. And that's a significant journalist, because sometimes people somehow think that they've got defence, that they didn't mean to say it, or it's not. A large number of libels stem from intentional mistakes, for example, the wrong picture of the wrong person. And the final important thing is that is where the burden of proof lies, because in libel actions, the person that we've accused doesn't have to show it's false. We have to show it's true. Now that is a complete defence, but is a lot harder to prove than it may sound. So it does mean that if you're going to be an investigative journalist, and major sort of investigative teams are sort of getting the sort of information together in the course of their research that would stand up to a libel action. If somebody sort of says, well, that's a lie, I'm not a cowboy, not a criminal. Well, that means proving it in a civil court. And if you recall a couple of high-profile cases, for example, even when you know you're right, doesn't mean that you will win the case. So if you recall some years ago when Jeffrey Archer won his original libel action over the allegations involving Coughlin, it was only later that subsequent information that allowed him to be prosecuted and jailed for perjury. And similarly, you can have situations where you think you're right. A few years ago there was a libel action involving World in Action and Marks and Spencer, where World in Action were accusing Marks and Spencer of selling goods that were marked made in England, which were not made in England, made in Africa. And the programme could show that. But Marks and Spencer sued, and World in Action were not in a position to show that Marks and Spencer knowingly sold those goods. That was the key word. They could show the goods were made in Africa and did carry made in England marks, but with the supply chain and the nature of those things, it couldn't prove the link that Marks and Spencer's knew that. And that, of course, was the issue that Marks and Spencer said that, they said the programme was making that allegation, that it was very damaging to them. And the problem with libel actions isn't so much the damages, which British courts have tried to keep down, so in that case 50,000, but the costs, because we're talking about, in the serious libel actions, a High Court case, which could quite easily rack up £500,000 in costs on both sides, with the loser paying the bill. Now, I don't know about you, but I don't think that many of the people that we work for are prepared to take that sort of £1 million gamble. So the simple answer is that justification, which is basically the defence that it's true and we can prove it, sounds like a good libel defence, but is flawed because it's often quite hard to prove something. It does mean, though, that investigative programmes will set out to get the evidence required to back up their claims. There are, however, and not enough time really to go into them in detail just now, some very important defences for libel, one of which is the freedom of speech sort of defence, which is fair comment, which is a defence of opinion and is very, very strong. If you've got an honest opinion and it's based on fact, expressed, with no improper motive on your part and on an issue that's in the public interest, that's a very sweeping defence, and that would cover you for your reviews and satire and comment columns and editorials and your personal comment pieces. And you'll be all the safer, if you like, in a review, for example. There's nothing stopping you criticising the restaurant or the play, but the safest way to do it is to give the evidence to support your claim, and rather than just being abusive, to explain, for example, if you're saying the acting's bad, in what way is it bad? Why is it bad? How is it bad? Is it because the wooden expression and the monotone voice? Give the evidence, and you've got a very strong sort of fair comment defence there. Reham asked, incidentally, just to finish on that point, the other sweeping and very powerful defence relates to privilege and circumstances where we've actually got protection in law for fairly inaccurately reporting things. Absolute privilege covers us for all court reports as long as we're fair and accurate. And qualified privilege, which is every bit as powerful, protects us at common law for our own parliament. We've certainly got privilege for, effectively, for every parliament in the world and all courts in the world, and international organisations and so on. And more importantly, as a form of privilege that we have to protect us for reporting what happens at council meetings and at public meetings, press conferences, and in a wide variety of situations like official statements and so on. And basically, if you're going to be a reporter particularly, that's a crucial bit of knowledge about when are you safe to use something. So the difference between your friend at the police station tipping you off about somebody being arrested, which is not safe, and if they're released without charge, and you've implied that they were guilty of something, then they can sue the world. The difference between that and an official statement, which is covered by privilege, which if you fairly inaccurate official police statement of somebody arrested, that's actually safe. So, without in any way trying to panic you, and it's something that I know that some of you, Scarlett and Alan and others have mentioned, those of you on the freelance courses have got a specific module where you this in some detail. Those who are on things like sub-editing and journalism